Friday, y'all.
Joining us now, law professor from Ole Miss, Professor Christopher Green. Good to see you there, Professor.
Good to see you.
Yes, sir. So, hope everything is well up in Oxford. Are you there today?
I am. We're getting to the end of the exam period. I think my new microphone is a little echoey, so I'll see if I can turn it down a little bit. So is it echoing for you too?
A little bit. It might be the speakers attached to your system there. Might want to turn those down a little bit and help out, or see what you can do. So while you're adjusting the technology there, we wanted to talk to you today about this social media free speech dilemma and possible liabilities that the social media platforms might have. And that's in the light, of course, of Elon Musk taking the reins at Twitter. And he has released just a trove of information here in the last couple of weeks that pretty much points to lots of suppression and content moderation with a slant towards really reducing the amount of content coming from more conservative-oriented users and really national personalities that were tweeting a lot of content related to that. We're now learning that the likes of Dan Bongino and Charlie Kirk, there were special features the Twitter management has, the content moderators have, that allowed them to really limit search of their content, their tweets, and information they shared, and also just throttled down the amplification in the case of Charlie Kirk and the content that he was putting out there. And it just seems like there was a deliberate attempt there, obviously, to do so. But more disturbingly is whether or not there was some collusion going on with the federal government. Were they taking orders from government officials in the moderation of content? And I'll be quiet and let you talk about that. It's a complex matter. What's different about these guys, for example, help us out with that, Professor, in standard, say, newsprint media or other digital media or even television media? How do they differ?
Well, yeah, the thing that is, the thing that is so striking about the current disputes that you get are the role of these algorithms and the fact that it's very difficult to distinguish between what is getting done by the algorithm itself in terms of recommending things for different people, what's being done by the management over it. I think some of these internal documents that we've seen are clearly indicating, hey, they came in and they knew what was going on. They knew what the results were. A number of people. So this started. I mean, I think anybody using Twitter, you notice when these algorithms change. You're clearly suddenly seeing different things. They used to have just a lot more encouragement. I would go on Twitter and they'd say, "Oh, that guy that you were arguing with all the time, he said more stuff. Do you want to?" It's sort of really encouraging me to argue with this one particular guy. And then suddenly, I'm getting this different stuff. They clearly tweaked that algorithm, and it is really hard to know whether. Without really getting into the details and knowing a lot of computer science, know how much of it is deliberate, how much is the result of particular deliberate decisions. You have some memos within Twitter, but this case the Supreme Court just granted review on a bit ago about support for terrorism. It has a lot of the same issues because they set up a system that allows you to kind of find people you like talking with. And tend to agree with. And, oh, my goodness, we've suddenly set up a platform that is helping ISIS find their people because it helps everybody find their people. Yeah. So Twitter now is saying, hey, we really should interpret so knowledge and substantial assistance for terrorism. That's what the statute about terrorism is talking about it. And they said, just giving the same service that we're giving to everybody, that's not substantial service for terrorism, even though it might be kind of the only way that ISIS can connect with people to carry out these terrorist attacks is through having these platforms. So there's a real difficult question about how much we're, like, as the government, as a people trying to defend ourselves, how much we're going to demand of these social media companies in terms of rooting out the bad guys and preventing them from forming their own terroristic communities. There's a separate question about just internet regulation in 230, but in terms of the algorithm and the fact that we're in an algorithmic age where there's necessarily a lack of transparency, no single person knows entirely what's going on. We're not quite to Skynet being self-conscious yet, but it's disturbing. It's a very very difficult environment to know what to do, either if you're running a company or if you're running advocating policies about how to regulate.
Yeah, I mean, it's a good point, because while humans set in motion and create the code, the underlying code that is these algorithms, and they include, of course, machine learning features in that. Once they put them out there, they sort of start to take a bit of a life of their own based on the nuances that's built into the code. But I think, someone that's technical enough, that's familiar enough with that process, could probably successfully argue that, well, the code was skewed in one direction from the get-go, and it just became, I guess, more intense, and it amped up over time as it consumed more, processed more content, and learned more. But it's a great point you make. I think there's a lot of folks probably in the general public that think there's just this army of people that are sitting in front of keyboards and screens that are seeing all this content come through and making decisions. That's really not how it works. It's all done electronically. It'd be impossible to hire enough people to do that with any degree of efficiency. And so that's not how it works. There's a little bit of that, no doubt. Certainly, though, it appears, Professor, decisions were made by management to blacklist, is what it's called, or shadow ban certain users that were right-wing oriented. That's been exposed. That looks like it's credible to me, at least. I don't know if you've looked at any of those documents, but they appear that way. The question from a legal perspective is that against the law for a private company like Twitter?
Well, so Texas and Florida have they've passed laws more or less telling Twitter, telling Facebook, telling a bunch of these social media places, hey, you have to serve people of all persuasions, political and religious. You have to treat them on a par with other citizens. Okay. So that's in keeping with our general tradition of regulating common carriers, taking it and moving it to viewpoint, which is traditionally one of the ways that all citizens have to be treated equally. You couldn't run a bridge and say, any citizen can cross the bridge. But Democratic people have to, members of the Democratic Party have to pay twice as much. I mean, you couldn't discriminate on the basis. And certainly, I mean, you kind of have the memos on top of the algorithms. And, the algorithms kind of spit out certain results. People look at the results, and the decision whether to care about that is obviously, I think it's on the basis of some of these memos, affected by the politics. Okay. So a lot of these two big new statutes, which I think the Supreme Court is probably going to review in the next year and a half. I think it's probably not going to get to the court by next June, but probably by mid 2024. And it's just a big question about how we function as a society when you've got these tech giants with so much power. And it really is kind of amazing that Musk, obviously $44 billion is a lot that he's got to pay to get in there, but he can make decisions saying, okay, Trump has got his account back, he's not using it again yet, but you got all these old tweets suddenly reappeared, and people can retweet them again. And this is because a single person decided, we're gonna have a more even-handed approach, even if it means getting some crazier stuff back online.
Yeah, We're up against a break right here. Can you hang in there with us, Professor, through the break and talk to us in another segment?
Sure.
Yeah, great. We want to talk to you further about this and also about the same-sex wedding website developer case that's going in front of the Supreme Court. We understand that you filed a brief in this case. Is that right?
That is right. I filed an amicus brief. They didn't call me out. They mentioned a few professors on Monday, but not me. But I may do what I can to highlight it with some more writing between now and June.
We'll cover it after the break. We're in the Element Wealth Studios. We're visiting with law professor Christopher Green. So, Professor, when we talk about the First Amendment before we go to the Supreme Court case, something that always kind of perplexes me is to what degree are private social media companies responsible for protecting the First Amendment? Now, I know you talked about a couple of states, I guess, who have enacted laws, which are, I assume, a condition of operating within those states. And I assume that's perfectly within their right, their purview, their legal authority to do so. I mean, it's just regulating an industry in their state. And I'm sure if that conflicts with the First Amendment or somehow is unconstitutional, those companies could file a lawsuit, get it all the way up to the Supreme Court, let the Supreme Court sort it out, whether or not the states exceeded their authority, I guess is the way that would flesh out legally. Okay, right. Go ahead, yeah. Yeah,
the net choice case, I'd hoped my new audio settings would prevent the echoing, but I think the only thing I could do is to turn off my speaker for a second.
Right.
But yeah, the net choice case is a First Amendment challenge to these laws. The internet company saying, "Hey, we have a right to speak." And that means a right to pick favorites. And if we want to be a Republican or a Democrat-leaning social media platform, we are entitled to do that. The reason that there is an argument on behalf of the government is the traditional kind of regulations that we put on common carriers. So if you're a cable company and we give you a special monopoly in order to go into people's homes with a cable, you get eminent domain power to run your service in a particular way to everybody. Well, in exchange for getting that benefit, long tradition. We're talking like back to the 17th century. So people like Chief Justice Hale talk about this. The difference between the jus privatum and the jus publicum. If you're just completely private, well, it doesn't matter to anybody what you do. That's be somebody who's not at a particular market bottleneck. And then you've got the public sphere. That's, the paradigm is somebody running a bridge. Okay, there's only one way to get over that bridge. You've got to say you have an obligation to serve everybody. Okay, and the question really is Twitter or our Facebook, our Google, are they like a bridge in the relevant respect? We had cases about the mall. So back in the 70s, Supreme Court said, well, as a matter of First Amendment doctrine, you don't have a right to go to somebody else's mall and speak. But if a state wants to tell a mall, you do have to let people come in to speak. The mall did not have a First Amendment right as a shield against that. So that's the big precedent that Texas and Florida are going to be relying on, this Pruneyard case from 1980.
Makes sense.
And as it happens, the same distinction is the one that was the centerpiece of my brief in the 303 Creative, because my argument is, look, if somebody's offering website services, this is a virtual service, so there's not even a market, a place you're going to. So if you remember the Masterpiece Cake Shop case a few years ago, well, there was an actual physical bakery, and the guy, Jack Phillips, said, I didn't want to sell wedding cakes for a same-sex wedding. You would have to walk about 0.3 of a mile, to another bakery. You can there's actually a map. You go to samesexweddings.com or something like that. It's got a list of all these places willing to sell things. So it was a really, really tiny imposition, virtually no limit. I would say no limit at all, really, on market access of people seeking wedding cakes for same-sex wedding. But with 303 Creative, there's nothing at all, because all she's doing, she's just in her home saying, hey, send me an email and I will set up a website for you with such and such a thing. You can send an email to somebody else just as easily. So there's not even a 0.3 of a mile. It seems to me that somebody selling website services, like individually where you have a market, is nothing at all like a bridge. Twitter itself, or Google or Facebook, that's a lot like a bridge. But the 303 Creative, Lori Smith, the woman who is involved in this litigation, is nothing at all like a bridge. There's just no market reason at all. There's no market access you're gaining by forcing particular marriage traditionalists out of the market. They're the ones who are losing access to the market. So if you want all Americans to get access to the market, which I think is the right principle, it just makes no sense to enforce this, other than people not wanting to have marriage traditionalists in these fields, which I think is not something the state of Colorado is allowed to care about under the 14th Amendment, and the way that First Amendment free speech principles come into the 14th Amendment.
Yeah, okay, that makes sense. That's an interesting distinction. So what you're saying is that from a legal perspective, the courts may look at a Twitter, for example, as having such a dominant, unique share of the market in what they do that they look like a monopoly. They maybe look like a utility company, and therefore perhaps the application of the law might be different in their case. That's what I'm taking from that. You make a great point with the case of the website developer, something we said on the program yesterday. It's not like you can't get other developers to do what you're looking for. They're out there, so they don't have something proprietary in that case. Don't have a patent or a franchise. We're the only ones that do websites like this. So before we move on to the case, this is the other question I have that comes up, Professor, is so-called hate speech. Who the heck determines what is hate speech? And in what we're getting now in the debate in the public square about Twitter is, oh my gosh, now that Elon Musk has got it, we're going to see this dramatic increase in hate speech. The problem is that's very subjective, and you seems like you get crossed between, well, what's a pure First Amendment, anybody can say everything they want on this platform, versus no, we got to have some reasonable limits on that. And maybe hate speech is one of those that some people would like to see, but you can't agree on what's hate speech. How do you deal with that?
Yeah, so, I mean, hate speech itself, that's not a category under the First Amendment. There is an old term, fighting words, which are like you go into a bar and you start a fight. So words that are going to cause somebody to imminently engage in violence. Okay, and for a long time, in the 1940s, we had a case where they say, "Oh yeah, of course, it's not the free speech doesn't include the right to start a fight by means of words." Okay, but really the category of hate speech, if you look at the way people use it, they just say, "Oh, it's speech that reflects bad attitudes inside your heart." And everybody's heart's got some bad attitudes, and they get angry.
So we're human,
but that's not the same as starting a fight in a bar. Yeah. So I think it's you have to really the cure for this kind of thinking is to really look carefully at the tangible circumstances. The idea that certain ideas, just by being ideas, are violent or are hateful. I think you really shouldn't be looking at that as any kind of justification at all for restricting it. You have to look at tangibly what actually happens. So you want to, I think it's reasonable to think you want to have a sphere where people are not insulting each other, physically confronting people unnecessarily. But to say, oh, we've got to shut down people for having ideas that are bad. Incitement to imminent lawless action has always been a traditional exception. So shouting fire falsely shouting fire in a theater, that kind of thing. But you really have to look carefully at the actual proximity of the action that's involved. Just saying, oh well, anybody who criticizes certain ideas is just ipso facto hateful. That's a very dangerous idea. Frankly, I think it's an idea that is not the nicest idea itself. It has a bit of the air of self-referential incoherence, I think.
Yeah, that makes sense. And the problem is, Professor, there's so many dimensions and aspects of what could be construed as so-called hate speech, and it's not as simple as the yelling fire when there's not one, and that causes some sort of problem. So it's fascinating, Professor. You're so knowledgeable about these matters, and we really appreciate you coming on middays and breaking it down for us. And congratulations on being part of the brief, part of the legal proceedings there with this, what's going to be a landmark case, I believe, before it's all said and done. Appreciate it, sir. Thank you.
Thanks for having me on. Enjoyed it.
You got it. Middays, SuperTalk Mississippi, coming right back after the break. Stay with us.